Okay. So I realize that I'm pretty much preaching to the choir here, but I think it's important to ask ourselves occasionally, is jury research really something that we want to invest our time and resources in? And you see these arguments occasionally in the literature. Jury trials are very rare. There's some nice data a few years ago from Mark Galanter indicating that they're becoming even rarer than they were previously, and they're hard to study, as we'll talk about, and courts and policymakers pretty much ignore the research that we do. So the question comes up, why bother? There are many reasons, of course, why we should study juries. It's what I like to call the bastion of democracy argument. You know, it's a hallmark of the American justice system. As we'll probably hear on Saturday, there are a lot of interesting innovations in other countries adopting jury trials, and we must be doing something right if other countries are following our lead. On a less philosophical level, but speaking a little more practically, there is evidence that juries cast a long shadow in the sense that jury verdicts and anticipated jury verdicts have a clear effect on settlement negotiations, individual and corporate behavior, and jury trials, even though rare, can have a major impact, such as death penalty litigation, death penalty cases, and tobacco litigation. So that's my argument for why what we do is a legitimate thing to be investing our time and resources on. Of course, there are numerous ways to skin a cat, to study juries. There are probably more methods than these, but these are the ones that I typically come across. We can observe jurors directly in situ. This is generally not allowed, of course. There are some interesting exceptions, such as the Arizona Jury Project, which has yielded some very interesting data, but for the most part, it's not practical to observe jurors as they're doing their job. Case studies and interviews of jurors after a trial has ended, archival analyses analyzing actual jury verdict data from jury reporters and so forth, experimental simulations, and field studies. Each of these methods, as we'll hear over the course of the conference, has its own pros and cons, which other speakers will doubtless address and which Norb talked about a little bit. So I'm going to limit my focus to experimental simulations. In choosing a methodology, we need to consider a number of questions, foremost among them, what do we want to know? What questions are we trying to answer? Christina distinguished between, I think, jury persuasion and jury performance was the other one. So my categorization here is similar to that, where sometimes we're interested in studying jury outcomes, looking mainly at verdicts, sentencing decisions, damages, and so forth. Other times we're interested in studying jury processes, the sorts of decision-making processes and reasoning styles that lead to those verdicts and which invoke things like the story model, which Christina talked about, persuasion strategies, heuristics and biases, and so forth. Some of the methods are particularly well suited to answering some of these questions, but not so good for others. Archival analyses, for example, are really good for looking at jury outcomes, but they typically do not contain much, if any, information on the reasoning processes that jurors engaged in to reach a verdict. On the other hand, looking at juror interviews and case studies is a nice way of looking at juror reasoning processes, but has little informative value on jury outcomes just because it's such a small sample size. One advantage of simulations is that they are very good at looking at both outcomes and processes. There are a number of advantages to simulations, and this goes in part to the different types of validity that we were discussing earlier. Experimental simulations allow for a very high degree of control, high internal validity, allowing researchers to make causal inferences. They're relatively inexpensive and easy to run, good for testing scientific theories. As I said, they allow researchers to address both process and outcome questions. And not trivially, I think, they really fit with our psychological training. and I say our, recognizing, of course, that not everyone in the room is a psychologist, but broader social scientific training and especially psychological training, where psychologists tend to rely on experiments because that's what we know and do. They afford the greatest control, and as Norb pointed out, they're the best way to advance scientific theory. The downside, of course, is that this often produces relatively artificial methods which lack verisimilitude. This is another way of talking about the validity question. Some of the research on this in the 1970s uses the term verisimilitude a lot, and I like it because it just kind of rolls off the tongue, you know, verisimilitude. But looking at what Margaret referred to in terms of ecological validity, you know, how truthful is the simulation in terms of capturing the real situation that jurors would face. Simulations sometimes ask the wrong questions, or in other words, they have low construct validity. And of course, there are policy limitations to doing experimental simulations as they stray farther and farther from the sorts of decisions that jurors would be making in the real world. I'm going to focus today on some of the pros and cons of jury simulations and the concerns that they raise, but it's important to keep in mind that simulations are everywhere. You know, we're looking at jury simulations, but there are many behaviors that we study by looking at the performance of these behaviors in simulated or analog conditions because real-world study or practice would be impractical. And I've listed just a few of them here where we, and I mean the research community broadly, use flight simulators to study pilot training. Medical training involves practicing on cadavers and dummies and computer simulations, virtual reality devices, game theory models, and of course most of the rest of psychology, in which we study individual and group behavior by asking people to perform simulated hypothetical tasks. We do this all the time, so jury simulations are not really anomalous within the context of psychological research, especially social psychological research and research in many other domains. The reason for this is that simulations are generally safer and more cost-effective and minimize ethical concerns. So, for example, if we use flight simulators instead of real planes to train pilots, it saves money and lives, and I've never seen anyone raise the argument that, you know, we should not study pilots' decision-making processes by putting them in a simulator before we study how they make decisions in a real plane. There are clear advantages to doing so. The problem, of course, is that using simulations assumes that the simulation is sufficiently realistic, that the results will generalize to more naturalistic contexts. So if you train the pilot in the simulator, yes, when he or she gets in a real plane, he'll be able to fly it. If you look at some social psychological research like Milgram's research on obedience, we're assuming that someone who shocks someone or would indicate an intention to shock someone as part of a psychological experiment would obey an actual order to commit an immoral act under duress in a time of war or what have you. And, you know, these are questionable assumptions. They might be true, but we need empirical data to support that. We can't know for certain until we examine the real-world context to see whether it does, in fact, generalize. And here we're assuming that real jurors would act the same as mock jurors, which is a testable assumption. And there's evidence on both sides, I think, as to how well it would generalize. The issues in doing jury simulations have been raised over a number of years by a lot of researchers, many in this room. I would especially like to acknowledge the contributions of Sherry and Norb and Neil for being among the earliest people to raise these issues and think about them in a thoughtful manner. And I hope that the Swan hasn't sung his last song, Norb, but that we'll be hearing more from you on these issues as well. All of these issues go in one way or another to the matter of verisimilitude. I could enumerate more, but I think this list subsumes the major issues. Who are the mock jurors? Are they representative of broader and more diverse jury pools? What is the research setting? much of the research that I've done is not in nearly as naturalistic a setting as the room upstairs that you just showed us. You know, it's a dimly lit, windowless cubicle in the psychology department at the University of Nebraska, by and large. And it's hard to know to what extent do the trappings of the room in which the whole thing is being presented would influence individuals' decisions. The trial medium, how do you present the trial? Is it a written summary, an audio tape, a videotape, a live trial, what have you? A variety of different dependent variables. Are we looking at individual or group decisions? I appreciated the irony that this is the conference on the future of jury research, whereas in fact we don't know a lot about juries. We know quite a bit about jurors, but we know precious little about juries, and to some extent that's okay, but there are other issues where it is important to look at the group decision, different sorts of judgments that the mock jurors make, the relevance of the task. And what I mean by this is the common observation that jury researchers often ask their mock jurors to make decisions that real jurors would never do. Sometimes this is really blatant, like asking them to make sentencing recommendations for types of cases where jurors would never do sentencing. Other times it's a little more subtle, asking them to make credibility judgments and so on, which we assume they do implicitly but would typically not do explicitly during trial. The data on simulations and whether these variables have an effect is a little bit sparse. I did a study a number of years ago looking at this question, and people have mentioned that study already. It's gained a certain, notoriety is maybe not the best word, but I do think that sometimes it's misconstrued a little bit, because I certainly did not say and still would not say that we can, ignore these issues altogether and go about using the most artificial methods at our disposal. What I did say, and still would maintain, though with a little less confidence, is that there's a dearth of evidence on the extent to which these variables matter. And maybe we should shift the burden of proof from having to demonstrate that these things do not matter to having to demonstrate the circumstances under which they do, because I fully believe that under certain circumstances these variables would matter a great deal. But we can't simply assume that they're automatically going to make a difference in all sorts of cases. So real quickly, what I did was review the literature on the topic, and especially focusing on law and human behavior, looking at how some of these methodological choices had evolved over time. And what I found was that although the number of simulation studies published in law and human behavior was increasing, so was the percentage of studies that were using students as opposed to community members as mock jurors, and that researchers were actually becoming somewhat less realistic in terms of the way that they presented the trial, in terms of using videotape trials. When I talk to people about this study, the question I most often get is, why didn't you just do a meta-analysis, so you could answer some of these questions statistically and conclusively? And I have a very simple answer for that, which is that I hadn't met Steve Penrod yet. So I didn't know how to do a meta-analysis, and I only dimly knew what a meta-analysis was in the mid-90s. So the good news is that with Jeff Neuschatz, I am now starting on a meta-analysis of this literature, but it's real early, so I don't have anything to tell you about the findings from that. What I found in the review was that there were very few studies, most of them were pretty old, and they showed little in the way of consistent differences as a function of the participant sample or the trial presentation medium. Fortunately, there's been a decent amount of research done since then, such as the recent issue of Behavioral Sciences and Law, edited by Rich, Dan, and Joel, and this is all to the good as it provides some additional data. This slide shows the new data portion of the talk, which will be alarmingly brief. But at various times since that study, I've had occasion to try and update it and look at how things have changed, not in a very systematic way. But what I did was look at law and human behavior from 2005 to 2006, and again from 2011 to 2012, through the first half of 2012. And as you can see from the figure, the number of simulations, at least in this one journal, has decreased somewhat precipitously, I would argue, so I would be interested to hear about possible explanations for that, but that the studies that are being published are becoming more realistic in the sense of using more community members, fewer students, and using more non-written materials, auditory trials, video trials, and there's even a great study from 2005 or 2006 by Gail Goodman and colleagues, which used live presentation of the trial. Now, this is only a single journal for select years. It's admittedly a convenient sample, but as you know from my research, I'm all about convenient samples, so why not use that here? I looked at some of the other issues a little bit more recently, the number of studies having deliberation, which is still a minority of studies, some very nice ones by Valerie and Edie, for example. And what I want to talk about for just a couple minutes in my remaining time, because I'm running out, is the importance of whether the mock jurors are making decisions that have any consequences. I refer to this as the consequentiality conundrum, which comes up occasionally. For the most part, we don't pay a lot of attention to it, but it's simply the issue that no matter how realistic you make a simulation, it is still a simulation with no real decisions for anyone involved. There are consequences for the litigants, of course, but for the jurors or mock jurors, knowing that you're making decisions that actually matter in some version of the world could influence the decision-making processes and the results. There is some evidence that the courts are concerned about this issue, and Jay presented some quotes where justices have called attention to the fact that the mock jurors are not making real decisions. The last quote there doesn't really have to do with jury simulations, but was just a great Scalia quote about psychology, so I threw it up there anyway. And I am out of time, so I'll try to be really brief, and I won't get through everything, but I do want to raise the issue that there is not much research looking at this consequentiality question because it's so difficult to do. Where if your question is, what's the effect of whether you're making a real decision or a hypothetical decision, there are a few different ways of going about that, but they all raise a host of ethical and practical concerns which are very hard to get around. A few years ago, I looked at the literature to see how much had been done, and not surprisingly, there are some familiar names up here, such as Kerr and Diamond. But I could only find a handful of studies. If people know of others, I'd be very interested in seeing them. But again, the research is somewhat inconsistent on whether knowing that you're making a real decision is going to influence jurors' decisions in some meaningful way. So I'll make this my last slide, but I would simply agree with some of the other speakers who've said that one of the important recommendations to use here is multiple methods. I call it convergence, triangulation. It's really the same thing, to demonstrate whether we're getting comparable findings across different methods. If so, we can be much more confident in the conclusions that we're reaching. I'll go ahead and stop there.
So when I thought about this conference, I'd like to thank everyone for inviting me, and Margaret for organizing, and the conference committee as well as NSF for sponsoring this event. It's a wonderful thing to come together with so many luminaries in the field. And then I had asked myself, why am I here? I'm not sure I belong with this group. I probably am the only clinician who was trained by a psycholinguist who studies jury decision making in the audience. So, and I probably have the longest title of anyone. The psycholinguist is probably sitting there at home in Indiana going, what did I teach him? This is completely indecipherable. But I'm going to do my best to add myself to some of the discussions that happened before, and hopefully not make it too much more muddled. But title of my talk, we're going to see the E word again, ecological validity, unfortunately. And my idea here is sort of talking about ecological validity a little bit more and talking about generalizability and how they interrelate and talking about this balancing that has to go on to do good research. So the brief overview of the talk a little bit about some of the terms we're going to be using, the trade-offs in validity, thinking about the purposes of research, and I have some quick fixes. You know, we talk about using college students. You know, I went away from college students for efficiency concerns. What? Efficiency concerns? I'm at a school that has 1,000 people in it. For me to get a sample of 200 students to participate takes me a year and a half. I did a study with one of my friends, Nick Skurridge from USC, who's now at UC Irvine. We collected 360 subjects in 24 hours on MTurk. Okay, now there's problems with using internet surveys, but we got so much more data in 24 hours, and I'll talk about that at the end, that I could possibly have done with my college students in a much better sample in a lot of respects. So we'll talk about some of the quick fixes that might improve the quality of research painlessly and cost effectively. So, as Brian pointed out, we know rates of jury decision making is decreasing in the US. I picked up some estimates from the Bureau of Justice Statistics suggesting they're decreasing. They're not very great, but Dennis Devine still estimates that over 150,000 jury trials a year. So it's still a substantial number of things we should be concerned about and still having this substantial effect on the decision-making process in the legal system. I also picked up some of Edie Green's research about how often we're seeing articles on related to jury decision-making research, and what we saw is a pretty big increase into the 1990s through 2000, and I think we're actually in the sort of in a valley point now, where we were seeing close to 59 studies a year being published in the major journals, and I think that probably is not true anymore. So why that is. And I'm going to speak mostly about simulated jury studies because they're the most common research that's being done by folks in the field at this point, and I've done quite a few of them, and I'm going to sort of comment on the mistakes I've made and the problems I had in designing these studies. But the benefits of the simulated jury study, as everyone's pointed out, is the internal validity. You get to control the variables you're interested in. You get to show cause and effect relationships, and that's very, very, very useful. But in terms of the peaks and valleys of research, we saw some data suggested from Brian. I'm not sure it suggested what you thought in terms of, it looked like the college student samples were still pretty damn high if you compared them over time, whereas we're seeing many more non-sort of written materials studies. And so I think there's an interesting question about the college student samples. And now that it's so easy to get non-college student samples, I'm not quite sure why we're still using them. Okay, so balancing types of validity in jury research. So we talked about internal validity, everyone knows what that is. These two are the ones I think people forget about, and they group them together. And this is the point Margaret was making earlier. External validity, the extent to which we can generalize results to populations and settings of theoretical interest. And it's primarily an empirical question. You always have to test it. There's no way to know about external validity unless you do empirical testing. But it allows for application to legal policy. If we're going to say we should change the jury system, we ought to know that our results generalize to the jury system more generally. And that's a question I think we don't often do a very good job on. And then the ecological validity, the extent to which the experimental situation mimics real-world setting under investigation. As a trained attorney, I often look at the simulations I see and I review for law and human behavior and other. I'm like, this isn't even remotely close to what actually happens. And it's almost hard for me to think about this as a legal setting question because the legal setting is so divorced from what's being presented. And so ecological validity has an important point, especially for the persuasiveness to legal decision makers. They seem to care way too much about this, and maybe wrongly so. And we need to think about how to educate them better to think better about ecological validity. And I think you really have to balance all three different concerns: ecological validity, external validity, and internal validity. And Norbert Kerr had a slide with 3 horns, and I like the 3 horns because I think sometimes when you get a lot of ecological validity, you lose generalizability. And we'll talk about why that is in a second. And I'll use examples from my research. So creating ecological validity, how do we do it? We have more realistic simulations. That's the easiest way to do it. We can make really great simulations. And NSF sponsored me at one point for a grant, and they gave me lots of money, and I made a great simulation. And I spent a lot of time on it. And I had legal procedures. I had opening and closing statements. I had multiple witnesses. I had evidence. I had cross-examination. Burdens of proof, they had verdict options, they had judicial instructions. I even did deliberations, although I still haven't analyzed that data because it takes so damn long to analyze deliberations. So if anyone wants 40 juries, 8 each, videotaped, I have everything available. I just haven't had the chance to get to it yet. Okay? But the easiest one to fix out of this group is the moralistic jurors. And we did this special issue that everyone's been talking about, and I already sent copies of one of the article to Neil and Sherry. And if anyone else wants a copy, I have it downloaded on my laptop now. I'm more than happy to send you a copy of. And we looked at these more realistic jury samples versus college students, and we found some significant differences, and sometimes we didn't find significant differences in the special issue. And of course, the answer is it depends. It depends on what you're studying. And so until, as Sherry's pointed out, until we have a realistic idea of why it matters and when it matters, we need to look at both groups and get more realistic samples to look at them. But the more realistic you make your simulation, you lose probably external validity in some sense. And you say, what? How is that possible? Well, when I was making my simulation, I was looking at sexually violent predator laws. And I had some great stuff. I had transcripts from Arizona from real cases. I had cross-examinations. I had all those things. But you got to remember, there are huge differences between jurisdictions. And so immediately when I start using laws from one jurisdiction, I limit how I can generalize to other jurisdictions. And no one really cares about Arizona's sexually violent predator law. I mean, some people might care in Arizona. But I was trying to talk more generally about sexually violent predator laws across the country. So the second I start doing this, I'm limiting myself and limiting the generalizability. So I made a very realistic simulation, but again, it's not clear how much that relates to other situations and other jurisdictions. Another good example of this is Rick Rogers did this study on Miranda warnings. Everyone knows what the Miranda warnings are, right? There's 532 different variations of the Miranda warning used in 560 jurisdictions in the US. And they vary from requiring a third grade reading level to requiring a postgraduate level reading level. So when we talk about studying the Miranda warning, we're not actually talking about one idea. We're talking about multiple ideas across jurisdictions. And unless we're willing to generalize and look at these things across these different situations, we're really not studying the thing we think we're studying. Okay? So there are jurisdictional differences in procedures and laws. There's jurisdictional differences in burdens of proof. For SVPs, half the jurisdictions use beyond a reasonable doubt, half use clear and convincing evidence. It's almost evenly split. Should burdens of proof make a difference? Dennis Devine tells me it often makes a difference from his book. You know, I look through and it turns out burdens of proof make a difference in people's decision making, but it depends on a lot of other factors. In Arizona, you need 6 of 8 jurors to make a decision about whether you civilly commit someone. 6 of 8, that's a really strange rule. But in my simulation, that's what I used. Can I generalize to other situations? Probably not without testing it. There isn't unanimity, which we often see. And in fact, my jurors, when they deliberated, they took an initial vote, and if 6 of them already had decided, they were done. Right? So it raises these interesting questions. And then you have trial practices. Arizona, for example, allows note-taking during the presentation of evidence. Other jurisdictions have different rules about voir dire, how you can ask voir dire. This is the point Christine Studebaker brought up earlier. Voir dire varies dramatically between jurisdictions. And so if I actually include a voir dire process, it's going to really limit what I can generalize my results to. And then probably the most important thing, the case-specific facts. I based it on a real case. So do my results generalize beyond the facts that I presented? And this is like, I think the elephant in the room was evidence strength, right? My particular simulation had almost all the SVP cases involved cases where they're going to win. So the evidence strength in favor of the person being committed was incredibly high, right? And so I got effects even with the expert testimony, even though the evidence strength was incredibly high, which says something, but at the same time, evidence strength is likely to interact with other factors that's really important in our decision-making process, and we do very little about keeping track of evidence strength in our simulations. And so it's very hard to tell when we're comparing different studies how they actually compare in terms of evidence strength, and is it likely to have an effect? And we mostly know when evidence strength is in the middle, we get better and stronger effects by and large. Okay? Cross-examination is always an interesting question, right? Do you do a specific cross-examination to the testimony, or do you change your cross-examination based on the testimony? And if you don't, you lose internal validity by changing your cross-examination, but what lawyer gives the exact same cross-examination to different testimony? And so you're always playing at these trade-offs that you have to sort of figure out and deal with. And then there are the extra legal issues that we don't talk about much, and then the things that Margaret was talking about. 5 minutes? Well, I'm gonna blow through it now, okay? Like the attractiveness of the litigants, the attractiveness of the attorney, things like that that are going to affect decision-making that we can't control easily and are clearly part of these realistic simulations we make. Do you have a defendant? Do you show the defendant? Is it a minority? Is it an attractive minority? Types of cases, civil versus criminal. Rich in his article found differences between different types of cases, homicide versus rape, in terms of jury decision-making. And then you have individual juror differences. You have regional differences. I reviewed a study from someone from UTEP. They had a college student sample. 87% of the sample was Hispanic. Okay? Can you generalize that from that to lots of different areas in the country? Probably not. I mean, there are going to be regional differences that are going to affect your decision-making process depending on what you're studying. Okay? And interactions between all these factors. So what I was saying here is that the dreaded four-way interaction, the juror type versus the evidence strength versus the type of case versus the burden of proof, how do you make sense of that when you do a simulation, when you make a very realistic simulation? So traditional approaches to psycholegal research, this is what I'm going to call 7-minute abs. So Sherry Damon came up with this brilliant idea in 1997 about two-stage theory. That was 8-minute abs, which everyone knows about, right? I'm going to suggest 7-minute abs. Tweak it just a little bit, take her brilliance, and just tweak it a little bit, and maybe people will pay attention to what I have to say. So her idea was start with strongly controlled internal validity, impoverished simulations, non-representative samples, and then stage 2 would get more realistic. But the problem is trying to publish anything is if you do stage 1 versus stage 2, you get beat up for external ecological validity. If you do stage 2, sometimes you get beat up for internal validity. It makes it very difficult to publish because someone's always going to find something wrong with your study. So I was thinking of a 4-stage approach. It's like 2, but better. Okay? And it depends on the question you're asking and what you care about in terms of your outcome. So it's a more continuous approach to ecological validity. And none of us do this work, atheoretical answers to legal questions, but I've reviewed articles about atheoretical work. And when there is not any theory, the ecological validity matters an awful lot. Okay, and then even these questions I came up with actually probably have theory associated with them. I'm not suggesting these are necessarily atheoretical, but I was trying to think of things that would be atheoretical that people might ask in psych and law. And when you have something that's so devoid from or not using the available psychological research, the question is, does it work in the legal system? And so you have to have a realistic simulation, otherwise you're not testing anything. Okay? So this is why I think ecological validity is most important when you have this non-theoretical research. You start with much more ecologically valid designs, but without theory it's impossible to even consider generalizing the results. And then you have to test all the generalizing questions you might have, like evidence strength, type of case, burden of proof, complexity of the case. Type 2, level 2, second level. Okay, I got 2 more minutes. I'm going to get through this. Or well-established psychological theory, which you want to generalize to the legal context. Sometimes we have well-established psychological theories that we think are important, and we just want to see if they work in the legal context. The example I use here is anchoring. Everyone knows that anchoring works. The question is, well, if we're going to test that, again, ecological validity is going to be much more important because we know it works in all these other situations. The only question is, does it work in the legal context? And so we want to make the legal context as close as we can to the real thing as possible. But you still want to consider external validity after you've shown it works. And the most interesting case here is when it doesn't generalize to the legal setting. Right? When we have a well-established psychological theory that has results it would predict and it doesn't work in the legal setting, that's really much more interesting than when it does. Finally, or second to finally, the third level. I should have gone with only 2. I'd be done by now. The third level, psychological theory used to explain more complex processes. Again, this is where ecological validity needs to come much later. You need to think about making sure you get your internal validity down and you're able to move from the internally valid and construct valid ideas to these broader ones. And then finally, there is some theory that's actually based strictly in psych and law. Dennis Devine has a nice theory that he's going to talk about later about jury deliberation. There's this story model we talked about earlier. There's things like stealing the thunder, which I think is completely derived from psych and law type thinking process. And again, this is theory that's specific to psych and law. We need to start at the bottom on this. And so we need to start from have very internally valid, we have to have construct validity, and build up from there. So here are my quick fixes. Better jury samples. Mechanical Turk, do people know about Mechanical Turk? You can get people online to do anything for 75 cents. Okay, so all you do is you set up a simulation, you put it online, and I am the least technically sophisticated person probably in the audience. I mean, I can't program my VCR, but I can run an MTurk study. You put it online, and in 24 hours, I had 360 responses to it. Now, there's questions about the sample you're using, but there's questions about any sample you're using. And so we need to think about that. But it's better than my college students. I have a much older sample. They're much more diverse in nature. And at a small liberal arts college that has very high SAT scores, probably lower than they reported to various organizations, but very high SAT scores, I'm not sure how that sample generalizes to anyone. And so having things like this available to me makes it very, very possible. The thing I just saw, too, one of my former students just worked for a jury consulting firm. They're talking about Google, what's it called? Google Hangouts. And this is an idea where you can video conference between multiple parties. And for me, this is the next level in terms of deliberation research, where you can have people have stimuli and then talk about it and have it recorded and have it transcribed. And this may not be as difficult to do in the future as people think it is. I mean, technology is going to make these things a lot easier. And so there is this possibility to actually have good simulations where you can have deliberations between people who are not necessarily in the same room. Now, there are problems, of course, associated with that and generalizing from that kind of different design, but it's an interesting idea and worth testing out, okay? And you can use college students for some things. If you're really interested in things like comprehension, higher level cognitive processing, really smart college students are a good test or a stringent test of whatever you're interested in. And then more standardized stimuli. This is the one thing I talked to Brian Cutler about last year, and I talked to Stan Brodsky. We should have a repository of stimuli that are available to people. I mean, this is what eyewitness people do so much better than us. And when we create these nice, great, realistic simulations, we should have them available for other researchers to use them. So we can do all the generalization that we would like to do with a lot of these models. What else do I want to say? Greater collaboration with the legal field. You all have this convergence. But we can really benefit from having people check out the ecological validity of our simulations and talking to people. When I was doing the SVP stuff, I talked to a bunch of prosecutors. Jurisdictions varied incredibly based on who the prosecutors were and how they did things. And so they had very different cases in Arizona versus California. Arizona the people had never lost a case. In California, they were about 50%. That's hugely different. And so the way these other factors that affect what goes to trial are very, very important. We need to think about these as well. And we can collaborate in designing and analyzing field research, archival research, and jury surveys. We need to examine the legal process and non-legal actor behavior. This is what I'm talking about, the prosecutors, and how cases go to trial, and what leads them to go to trial, and what's different about certain jurisdictions and other things, and develop better models of jury decision making. And finally, more conferences. This was awesome. And training for graduate students and young faculty. I mean, every young researcher should have to come here, not listen to me, but listen to everyone else that's here, and get some ideas about how to take the next step. So thank you very much, and hopefully I didn't go over too much.
Thank you very much for inviting me, and I think I have a distinction and maybe a different perspective. I was saying to Ko Chung Wang that I think there are only two people in this room who are only trained in law, and we are them, right? And he's not American law. So there's only one person in this room whose only training is American law, and that's me. And so I'm not burdened by the PhD in psychology or any other discipline, and therefore may tend to see things a little differently. You're in a law school. You know, we worry about juries, but we worry about cases, right? Real cases, and we tend to focus on what's going on in real cases more than the experiments, though I think, you know, both are important. But everyone, and it's a little bit, to an external observer, it's a little bit like a tribe getting together and talking about their inter-tribe disputes, right? And by the way, there's a big picture out there, and I think we often get mired in our inter-tribe disputes within law school, certainly, and within any discipline, and sometimes maybe don't focus on the big picture enough to make as much contribution as we could. So one question is, you know, so the nasty way of phrasing it is, okay, juries have problems, you make all these findings about juries, so what? We're not going to get rid of dispute resolution. Somebody's going to resolve cases, as Shari said this morning. Compared to what? And it seems to me compared to what is the big question. Of course, it's true we can make good progress on improving jury decision-making and jury trials, but it's against a background of choosing between judge and jury, and maybe arbitrator as a third kind of professional dispute resolution person. But unless juries materially differ from the others, well, I think one consequence of the intensive focus of psychology on juries is actually to discredit them, because lots of studies find flaws in the jury process or the jury method of decision making, and there's no comparable studies of judges saying what idiots they are, right? And so naturally all the attention focuses on, wow, this jury system's really flawed. Well, if we had a pure judge system, they would get a lot more attention, and it would turn out, I suspect, to be at least as equally flawed. So the bottom line question is always compared to what? And we know something about that. And I think also within the inter-tribe psychology debate, you know, what exactly should the sample be? I think the sort of starting point should be, we're studying people, right? We're not studying jurors. We're studying people. right? There's an important subclass of people, judges. And our findings might be just as valid with respect to judges as they are with respect to individual jurors, because it turns out judges are people, right? And so when you're studying people, you're actually studying both jurors and judges, and shouldn't be afraid to say so, right? I think there's a little bit of fear, I'm just making up, but I think there's a little bit of fear of people not trained in law to say something about judges. And it may be time for, in the words of the song in the Book of Mormon, for psychology to man up, right? And say something about judges a little more often, and not just say, look, we found all these flawed decision-making by juries. You're finding it about judges to about the same degree you're finding it about juries. I think you're afraid to say it because taking on judges is a little scary without legal training. And also, they're not a very nice group to criticize. They don't take it well. They're not used to being criticized. Okay, so I'll give two instances of real-world stuff, but judge-jury agreement, right? And I'm sure I've left some stuff out because I probably didn't devote enough time to finding all the studies comparing juries and judges. But we have 5 criminal studies there, and does this come out? We have 5 criminal studies there, and those in the business of meta-analysis. You put up the confidence intervals around those numbers, and I'll bet they overlap. That is, we probably have very little inconsistency in the rates at which judges and jury disagree across studies, spanning now quite a few years, right? When Calvin and Zeisel, we did it 40 years after Calvin and Zeisel, we got almost the same numbers, right? And so, and those aren't unlike numbers gotten many years before. This is a really interesting article in some familiar journal. Interjudge agreement, at last. We have studies of interjudge agreement. Does this work? Yes, it works on my hand. It doesn't work on, there it is, right? So the conditions here are no confession, high pressure confession, low pressure confession, like high pressure I assume means illegal, low pressure less illegal, no confession, weak evidence, strong evidence, no confession, strong evidence, 83% agreement among judges. Well, go back a slide or two. Look at jury rates of agreement. No confession, weak evidence, 83% agreement among judges, at least if my subtraction's right. And I think this overstates the rate of real-world agreement because in a non-experimental setting, a lot of these cases would plead, and the residual cases that went to trial would be harder on average than the ones that plead. So 83% is probably overstating the rate of agreement among judges, right? So now I can start saying, wow, juries agree with judges more than judges agree with judges, which sounds silly. Okay, civil cases. We have that famous one page or so in Calvin and Zeisel, 78%, and a bunch of other studies. Won't point out the outlier here, but this is the lowest, but confidence intervals probably overlap if I had bothered to calculate them. And so we have, again, rather consistent agreement, roughly 75, 80% civil, criminal, and interjudge, according to the Law and Human Behavior article. I mean, the bottom line, well, no bottom line yet. What about other law-related experts? Years ago, I came across data, the highest court in the Netherlands, the Hoge Raad, the Attorney General makes a recommendation to the High Court. The Attorney General is a neutral expert. Right? He makes a recommendation to the High Court. How often did the court agree with him? 84% of the time. In an earlier study, longer time period, 77% of the time. Again, right in the ballpark of judge and jury agreement. These are a series of studies. This is, I think, one study. Well, a bunch of studies of CST, competence to stand trial. Right? And you had multiple raters evaluating. The reason I included this, it's a legal issue, right? And there's a kind of yes-no outcome, just like the outcome of a case. What are the rates of agreement? Well, this one's interesting, 98%. All the rest, about the rate of judge-jury agreement. So what we could say so far is juries and judges agree about as much as legal experts agree, not noticeably different, about as much as psychiatric experts agree on a legal question, not noticeably different. And so I think all of your research actually has implications for judges, and it would be useful perhaps to not talk about researching humans and include judges among them rather than just juries, so that the juries don't get all the heat, which is what happens when you say jury, jury, jury. This is the relation between punitive and compensatory damages across 7 subdivided data sets, basically. The x-axis is the compensatory award, the y-axis is the punitive award, sort of a different rate of judge-jury agreement, or a different measure of it. 3 of these are bench trials. Here, this diagonal is bench trials. If your eye is fitting a line to those data, it's not different than the line for jury trials. That is, per unit of compensatory damages, judges and juries do not significantly differ. It could be that the juries are just crazy in both, compensatory and punitive, or it could be judges are people, and they actually behave like jurors, and juries behave like judges. This is an interesting one. The last one was the level of punitive awards. This is the rate of giving a punitive award. And we have, in cases in which punitives were sought, so I've divided this into personal injury cases, we see juries gave a lower percent of punitive damages than judges. This stratifies it by the level of compensatory, but the bottom line is here, in personal injury cases, judges gave punitive damages at a higher rate than juries, right? In financial injury cases, it flipped. Juries gave it at a higher rate than judges. Kind of exactly the opposite of what I think stereotypes of juries would be, in the sense of we think the juries are more prone to favor injured plaintiffs rather than others, but I don't know. I don't have a good explanation for this result, but the fact that in one category of cases goes one way and another the other way could be maybe there's just something else going on. Okay. So my colleague Jeff Raklinsky and Chris Guthrie and others, Andrew Wistrich, went through all the cognitive, I guess we call these heuristics now. So here they are. And this is judges as compared to other decision makers. So here's the 5 heuristics. Comparable to other decision makers, comparable. In 2 dimensions, judges were better, but they still had the heuristic problem that humans have, right? All of that is by virtue of saying either more emphasis in discussion or actual study of judges would really be welcome. And if one of the concerns is law and human behavior isn't getting enough articles or acceptable articles on juries, it may be if you join study of juries with study of judges, the salience and importance of the article becomes much more persuasive, I think. Some caution and experiments. So we have, despite the punitive damages data I put up, we have at least 2 studies I've dug into in some detail by very good people, Cass Sunstein and Kip Viscusi and Joni Hirsch, on punitive damages, both of whom pronounced there was no relation between compensatory and punitive damages, and both were shown to be wrong when the data were actually analyzed by someone else. In one case, it just simply involved taking a logarithm to normalize the data. In the other case, it required attention to regression assumptions and taking logarithms. But the 2 efforts to show that juries award punitive damages at random levels have been incorrect. Okay, capital punishment. So this is hard to resist just because Milgram seems so famous and you could never do it anymore. People leapt at conclusions from the Milgram experiment with respect to the behavior of capital jurors, right? His experimental results on obedience to authority dominate much of the thinking about how capital punishment, I guess I'm quoting myself here, about how capital jurors deal with the question of sentence and responsibility. Milgram's and other psychological results provide a basis for hypothesizing about jury behavior. The basic notion being that jurors who have to sentence to death will seek to shift responsibility to another source, such as the law or the judge. That is, oh, we're sitting here deciding life and death, but it's really not us, it's someone else. And that was a theory based on the Milgram experiment. When you ask jurors, now there's more subtlety to this than this one slide shows, but when you ask jurors, who did you think that whether the defendant lived or died, this is actual jurors in real capital cases, did you think that whether the defendant lived or died was strictly the juror's responsibility? And here we divided it by life and death jurors. Mostly the jury's responsibility. We have this column 61% for life jurors, 58% for death jurors. Only relatively small numbers said it was mostly the judges in the appeals court. That is, juries were accepting basically full responsibility, or at least substantial responsibility, for the most important decision they'll make in their lives, which is to sentence someone to life or death. And the experimental notion derived by many capital punishment analysts from the Milgram experiments just didn't seem to play true in the real world, that they weren't shunning responsibility. And so I guess my first major, well, I have a conclusion slide, sorry. Oh, this is even better. Right. I think there's sort of a latent bias against juries, even among people who like them. That is, they keep finding problems with them, which is fine, but they don't seem to reconcile their findings with real cases or with judges, and it leads to sort of a cascading anti-jury sentiment or perception of juries as wild and crazy. This is interesting. I think this is either out or coming out in December in JELS, right? The experimental design was actual negligent medical care, right? They gave the jurors behavior by doctors that said, this doctor was negligent, right? The plaintiffs won 46% of the cases, right? In a manipulation in which they should win 100%. I think we've succeeded over the years in creating sort of a anti-recovery bias among jurors. And so I think experts are contributing to sort of an anti-jury bias, and jurors, I think, look at Valerie's work and Neil's work in North Carolina, jurors kind of behave more hostilely to plaintiffs than they should. And I'm not sure exactly where it comes from, but I'm not sure that we haven't contributed to that. And I'm out of time, so you won't get the conclusions. Okay. Thank you.
I actually had my original plan and then what became my plan. And what happened in my original plan, and I'm actually now glad I didn't do it because so many of you have done it so well, is to think about, you know, what are your goals, to think about what we've learned about ecological validity by reading all this stuff. What are your goals? Are you trying to build science, or are you trying to build a legal impact? And let's, you know, use one method for the other. And I think that's a really great strategy, but it also, for me, was based on this assumption I have that the courts are really being aggressively critical of the quality of jury studies. And I'm very influenced by a small number of very salient cases. Lockhart had a big influence on me in thinking about this issue. Sherry's experience in the Seventh Circuit with the Free case also had an impact on me in thinking about this. And the Exxon dispute. Obviously, in this room, we had our own debates. It was something that was very front and center. But I don't know how, I can't really answer these other questions, which is, you know, how much of an impact are we having on the legal literature? Well, on court opinions. And how much use are we to them? And when we are of use to them, are they, or cited by them, are they discussing issues of ecological validity, external validity, however the label, you know, are they critiquing method? And so I'm doing highly exploratory work. I'm taking a risk in a panel on methodology to give you very, very, very limited data and hope that you will indulge me on this, which was simply to answer my own question quick and dirty style. So I fired up Lexis with no date restriction and looked at three kind of databases which would have, you know, importance in the legal literature as opinions. The U.S. Supreme Court, the U.S. Appeals Courts, and then the database of all state Supreme Courts. And I simply wanted to know, you know, when are we seeing jury research that we do? But of course, typing jury as a search term here is not a good idea. So I had to limit it, and I nods to Margaret in the room. I simply looked for how often is law and human behavior being cited in these decisions. This is why I underlined exploratory. Of course, this is a very limited way of looking at it, but it was beginning for me to sort of fill in the picture a little bit. And so I used both the legal citation for this and then a broader citation which comes up both ways. And my questions were, how often is it cited and how often are those cites about jury research, and is there commentary associated with that about methodology? Okay. The U.S. Supreme Court has cited LHB 12 times over the years, and I have this arbitrary date of 1998 as modern or recent or some demarcator of before and after, and it's completely arbitrary. And there have been 4 cases since 1998. Only 2 of those cases use data that is also since 1998, so citing current research, not just sort of recycling old or well-worn work that we've done before. For the U.S. Courts of Appeals, I found 28 cases, the majority of which have been since 1998, and about half of those use somewhat more recent data. And importantly, there is a concentration of courts that will make use of non-human behavior research. The 6th is very active with it. The 9th and the 7th account for about half of all of those citations. Close to 100 cases in state Supreme Courts, and half of those quite recently, and half of those are using recent data, and high concentration in some states. And so Connecticut and New Jersey has had big debates within their state Supreme Courts about both eyewitness testimony and about death qualification, and so has made a lot of use of non-human behavior data on that, with Massachusetts, Indiana, Washington, and Wisconsin weighing in as well. What are the topics, and are they jury-related or not jury-related? So for, and I'll tell you that jury-related is even a kind of problematic construct itself, but of the 12 U.S. Supreme Court cases, these are the topics that they covered, the most recent one being the Perry decision about eyewitness evidence, in which Sotomayor cited some work in her dissenting opinion. Obviously, punitive damages, my personal favorite about race and the excluded, those excluded by the peremptory, the insanity defense, and 2 cases on death qualification, and then a kind of footnoted cite to a study that looked at whether a defendant was wearing prison garb or was under supervision of an authority, and cited it to say, we can't make heads or tails of this, so we're just going to rely on our common sense. But it was cited. Then these are some of the issues of not juror-related, and that have to do with polygraph, with what you do with mentally disordered offenders, predicting violence, civil commitment standards. The child witnesses one, as I'll say, is dicey, that's talking about their competence, but often talking about it as how they will affect a jury. But I really only cited it, I looked at it as making a statement about how child witnesses are. Okay. The appeals court, again, I'm keeping jury-related cites pretty conservative. So there's lots of jury-related cites in eyewitness testimony research because some of that talks about the effect on the jury, but often that's as part of multiple cites that they do, and so I just kept it over in the eyewitness category, and ditto for child witnesses. You had there were 28 cases. 12 of them are what I'm calling jury-related. 3 on prior conviction, all about the Whistler and Sachs piece on that. 3 on the death qualification, some version of the symposium that came out in '84. Steve's work on note-taking, 1 on anonymous juries, a single case that looked at joinder, insanity defense, and 1 court that said there are lots of examples of rigorous empirical studies of jury behavior, and then gave a recent piece by Neuschatz and Meissner as an example, and then also cited Dennis's work and Ted's work. So it was part of kind of saying there's all these other great studies, but that's not what we're looking at here, so we're not going to use them. And then you can see where the non-juror-related cases are. They're in eyewitness, confessions. Bill Thompson did this work on the prosecutor fallacy, the defense attorney fallacy, that gets cited a couple times. Children as witnesses, recidivism, lie detector, and other. So again, close to 100 cases in state Supreme Courts, and these are dominated by two topics, which would be eyewitnesses on the non-jury side, and again, some jury implications there, and death qualification on the jury side. But lots of other topics, lots of other things that they are making use of, which would be prior convictions, again, the Whistler and Sachs, note-taking, insanity defense, Neil and Regina's work on BWS, anything on voir dire. There was a simulation that Jones did several years ago that got cited, Summers and Norton. So one piece on pretrial publicity about jurors not being good at recognizing their own bias, reasonable doubt definitions, and then one on jointer, one on Sherry's piece with Jason on DNA evidence, Valerie's piece on insurance, and the power of confession evidence in the context of a trial, how very important that is. And then you can see kind of, there were 10 others, but you can see kind of the leading contenders among the non-juror related issues. So that gives you a sense of where jury research is coming out. Do they talk about what I'll call ecological validity, just methodology much? It's really actually hard to define somewhat when they're talking about it, so this is a loose categorization. I read, when they talked about Reed's work on juries, they put juror in quote, and so I said, well, in a really lenient definition, we'll call that sort of a wrap on the ecological validity, but that's very, very generously. The death qualification, obviously, quite clear. The appeals court, just 4 of the 28, and in the state Supreme Courts, a discussion occurs in about 10% of the cases where there's some commentary on that. Now, what kinds of cases are they talking about? It only concerns research on juries. It only concerns research on eyewitnesses, confessions, and the polygraph. And the polygraph would be, no problem, the polygraph would be, how good is it? Should we allow it in, et cetera? Well, how good are the tests of its reliability? And there's some discussion going back, and quite lengthy discussions going back and forth about what can we learn from simulations versus what we know from the field. For juries, the subset that is about juries, it's only discussed in terms of death qualification and prior conviction. Now, so the story I have is quite for one journal, a fair number of citations in quite high courts, but not much discussion of ecological validity. Would I now say, oh, you all do not need to worry about ecological validity? No, but I do have some thoughts about it. First off, there are several reasonable good explanations about the particular pattern of the low level of discussion of ecological validity. One is they could just have selected the absolute best studies that don't have ecological validity as a primary thing. One is to provide some data to Norv's thoughts. They are very, very often using them to make an argument. So they're using them in a dissent where they're trying to say the court has this wrong, and there's all these reasons why they have this wrong, and no one is going to cite empirical support for that and then say, oh, but it's a really limited study. So they're using it to further their argument. In the case of death qualification, the dissent is very often on our side, but often the majority is countering with some critique. And they're also, in addition, even though we felt in Lockhart like they didn't understand the principle of thinking of a body as a whole, a research field as a whole, as thinking about it as multiply understood, there's plenty of times when they are thinking about one study in the context of all the other studies that are with it, and they use string citations. They're citing multiple studies to make their point, of which an LHB site is but one. Okay, so it is not that they don't think about ecological validity at all, but it doesn't get explicitly mentioned as often as my Lockhart-based thinking would think that it is. And I think what I'm seeing is jury scholars inform. Are we having an impact? Are we changing? Not necessarily. I think we would have heard about all those cases otherwise. But we are informing the courts. They are, whether the information is brought to them through the advocates or they have dutiful clerks who are looking up things or whatever it is coming across their desk and they are giving thought to it and are using, in many ways, research on that. And I would like to take that seriously. And I would like to say that we should build as good a database as we can. And I take a nod, as I referenced earlier, I take a nod from the eyewitness literature. And the fact that they have done so much work on building up the science of what they understand and just the sheer volume so that they can say there are over 2,000 studies showing this is a very powerful argument and has penetrated. And it's because they have paid attention to understanding what they want to understand, and they are not a subspecialty that is overrun with ecological validity concerns, studies. They're not, they have the same rap that it's unrealistic, we don't know, but they are hanging in there with it. And in addition, paying attention to topics that need more data. And this will be my last thing, is I think my little quick review identified some areas in which we are in deficit, and I would take very seriously. One is courts are struggling with real trials in the field and real issues that come up in real trials. And I do think that we can do more to provide them with data from the field, and in things that are very relevant to the jury but aren't only about deliberating in a room together. So they are struggling with jury composition issues. They're struggling with who's in their pool. And we need much more data on who's in the pool and what that looks like. We're citing stuff that is several decades old, and the modern experience of jury representativeness is quite complicated, and the reasons that bring people to court or not is quite complicated, and we don't have enough information to tell them. We need more of the kind of work Steve was doing on varying trial procedures in the field. It is hard to do, it's hard to get support for, but it has such an impact in it, and I think courts really pay attention to that. We also have a tendency, and Edie's made this point before, others have made this point before, we drop topics when the court doesn't go our way. So, there's been almost no work on death qualification since Lockhart. But the courts, every once in a while, it comes up in state Supreme Courts because advocates will say, well, okay, so it's not a federal constitutional issue, but under our state constitution, this should be wrong, and you should consider this. And, doesn't work as much, but it's another avenue, and we haven't been able to really give them new information on this and additional understanding of it. Prior records, the effective prior record, could be built up to a much greater extent and have a much deeper bench of literature. And at least from law and human behavior, pretty much all but 2 studies that I found were about criminal. That has to do with what gets appealed, what goes up to the docket of the appeals courts. But to the extent that insurance sometimes does make it up there, other issues relevant to the civil trial, I think we could be providing more. And I am done.
Well, the idea of commenting on methodological issues struck me as one that's, we've been talking about this since 1979. I think that was the first issue of law, or the first time that law and human behavior had a special issue that was devoted to simulation work. And Neil had a piece there, Sherry had a piece there. Some of the rest of you weren't born. So we've been talking about this for a very long time. And I thought back to 1979. That's when stamps cost 15 cents and gas cost 86 cents a gallon. And so really, where have we come and what can I add? Kind of a daunting task. So what I'm going to do is comment a bit on each of these papers and offer, again, a few comparisons to the eyewitness field, and then I want to talk about triangulation with a twist. But first I'd like to give a shout out to Dennis's book, because I think if you haven't read it, you should. Not only is it very comprehensive, but it's eminently readable. And he has provided for us the service of most recently looking at all the studies in our field. And not surprisingly, tells us that they sort of come at us in a bell-shaped curve. So there's some that are really fabulous. There are a few that are quite good. There are a lot that are sort of in the middle. There's some that have serious limitations, and then there are a few that should never have been done. And that makes total sense, but I mean, it sort of makes intuitive sense, but I'm happy to hear from the person who's looked at this literature most recently that that's how these studies fall out. So thank you for that, Dennis. I'm also happy to have some new data on simulations that Brian provided for us. I think his most interesting point is that the studies, at least those published in LHB, are becoming rarer and more realistic. And so I scratched my head about this a bit to asking myself why. Are simulations really done less frequently today? I don't know, though I'll tell you that I've sort of backed away from them because I just don't think that I can do them well. And I think perhaps as the bar has risen and as we have examples of people really doing sophisticated jury simulations, it's perhaps caused some of the rest of us to pause and ask, if we can't do that, would we rather go and study elder law and psychology like I've done, or some other thing, rather than contribute in a not so meaningful way to the literature. So it may be, in fact, that there are fewer simulations. Are they becoming more realistic? Well, some obviously are. We have the Arizona Jury Project to emulate. And I think there's been some discussion here about the way that technology will change our ability to do jury research in the future. And I think that is quite likely to happen in terms of being able to have access to more realistic trial stimuli, to have a diverse population more accessible to us, and to use some sophisticated methods for data collection. So I do think that there will be, that may, I don't know, bring in a new young crop of researchers that have those kinds of, the technical stuff at their hands. I suspect shoddy research is still getting published, just probably not in law and human behavior, shoddy jury research, which leads me to another thought about one of Brian's points, was that simulations, an advantage he claims of simulations is that they're easy to do, quick and easy to do. I'm not sure I would think about that as an advantage. I almost think that that's what may perhaps lead to some of these studies that we've all reviewed. And you ask yourself, why me? I guess that it's so easy to do leads to some atheoretical tests of some sort of obscure issues. But I certainly support your call for using multiple methodologies, and I'll come back to that point in a minute. I think Dan made the really interesting point that it's jury research, good jury research requires the balancing of these three different concerns: internal validity, external validity, and ecological validity. And that's another reason, I think, why the studies are so easy to critique, because there's always one of those that is deficient. And so it's, a good reviewer will always have something to say about what part of that study is insufficient. And that may in part explain why the acceptance rates for these, this kind of work in law and human behavior is lower than the acceptance rates for other kinds of studies. That's right? Yeah, okay. And I also liked Dan's extension of the theory that for the 2-stage to the 4-stage, even though you didn't, you would have been able to flesh it out better if you'd only had 2 to talk about. But I think especially that last stage where you're talking about the development of psycholegal theory, and I think if I'm getting your point, I think it's that the ecological validity can actually increase with the specificity of the theory to the jury context. And that kind of debunks the notion that theoretical sophistication and any real-world usefulness are necessarily mutually exclusive. And I think that's a really an interesting idea and way to way to put this together. Bless you, Ted, for bringing us some alternative way of thinking about this. And I think you and your colleagues have done some really important work over the years on using archival methodology, and including some attempts to statistically control for selection effects. That's always the problem with archival work like this. There could be some lingering issues about the fact that disputants would opt to take certain issues to a judge and other issues to a jury, but if that's the case, then your numbers may actually be underestimates of the degree of convergence. And fortunately, there's a simulation study, back to the idea of triangulation, that Jen Robinault did a few years ago that asked judges and jurors to decide punitive damages in a products liability case and found results that were quite consistent with this archival research. The other really interesting point that you made is really, I guess, is a tangent to our discussion here, but that was about the rates of consensus among psychologists and psychiatrists in those competence to stand trial judgments. What is the acceptable rate there? Or what is even really the acceptable rate with jurors and judges? Are we okay if the decision makers reach a different conclusion in 1 out of every 4 cases? What about 1 out of every 3 cases? I guess really the important point here is those kinds of findings should, and I think have, launched some follow-up studies that use different methodologies to try to address that question. Let's see, who is next? Mary. It should have been so obvious to us, Mary, that one measure of the quality of jury research is how it's been received in the legal community, but we haven't asked that question in a long time, so thank you. How do the courts really talk about social science, and how often do they critique its methodology? I think it's a little concerning. I did some quick math. I think it's a little concerning that it seems as though the federal courts have cited there have been only 8 cases in the federal courts that have cited LHB studies conducted any time in the last 14 years. I'm assuming that the Supreme Court and the courts of appeals sort of were, the same cases. Wow, 14 years ago, there's been a huge amount that we've learned in 14 years, and so how come the courts aren't getting that? Mary's data suggests that the problems are not that they are concerned about our methodologies. So then a tangential question is how, should we be shouting louder? Should we be doing something differently to get to the attorneys who would get our work in front of these courts? It's interesting that the courts rarely brought up concerns about ecological validity. Maybe it's because the studies were high on that dimension. You'd think that there would be, in briefs and in oral arguments, you'd think that there would be a lot of attention to methodological flaws in the evidence that's presented by one's opponent. But apparently that never or rarely got mentioned by the courts. And I also then want to amplify Mary's point about eyewitness researchers having carefully built up their science. And as others have said, yet they face so many of the same kinds of challenges to their work that we do. So I guess I wonder, should we be having eyewitness research envy? If so, what should we do about it? It seems as though if anybody who's been looking has seen that the eyewitness stuff has really been embraced by Attorney General, by courts, by legislatures, by police departments. And in Mary's terminology, our work is informing but not reforming. Well, I suppose you could look at, there are many places now juries get written instructions and they get to note take and they get to ask questions. So there's been some of that, but not to the extent, I think, that there has been in the eyewitness literature. And my last point is about, many of you have commented on the triangulation idea, the convergence of multiple methods. I think that means a few things. One is don't do what I do, which is this sort of scattershot thing where you do a study on this topic and study on that topic, study over there and study over here. I think Valerie's work on talking to business, her work on business on trial was really a lovely example of how you you can do systematically, you can do interview studies that inform focus group discussion, that inform surveys, that inform simulations. And she built that up over time in a really lovely way. And I'll just make one more pitch for somebody in this room, and that's that Neil said something years ago that I think is also very helpful, and that's that if you want to really learn about a jury, you just got to go see them, or you just ought to spend some time in a courtroom watching things unfold there. I think you said something like watching one trial will teach you more than doing many, many simulations. So both in providing the questions and in really understanding the richness of the context in which our questions are being answered, are being asked, I think that's terrific advice. So thank you.
Hi, I'm Brian Cutler, and I'll also thank Margaret for the opportunity and for the conference. And I've been thinking and talking a lot about methods lately, owing to a decision I made in 2008 to take a faculty position at this new university in Canada. For 20 years, I had been in a traditional psychology department, 2 different traditional psychology departments, where we didn't really talk much about methods because they were more or less taken for granted. We all had laboratories, we did laboratory research. We talked about methods, but they were relatively mundane issues, such as whether to use within or between subjects design, or what computer program to use to present stimuli. But when I took the job in Ontario, I joined an interdisciplinary faculty. At the time, it was Criminology, Justice, and Policy Studies. There were 3 other assistant professors who were psychologists, but the rest were political scientists, sociologists, anthropologists, legal studies, variety of other disciplines. And methods were no longer taken for granted. And a couple things came out of this. One is gaining a great appreciation for the methods that are used in other disciplines, learning about both their strengths and weaknesses, but also really relearning, re-exploring my own methods. And I gained a very strong appreciation and really came to value even more than I had previously my training, which was in experimental social psychology. And for that, I have Steve Penrod to thank for a lot of that, and other faculty members at the University of Wisconsin for really, gaining yet a new appreciation for the methods that I use, which are unabashedly laboratory research methods for the most part. So with that in mind, I also wanted to touch on some general issues that have cut across the presentations, and then comment along the way on a few of the issues in particular. Knowing that ecological validity was going to be a topic of discussion, I had reread some literature on how others have thought about ecological validity, and I wanted to just read to you one brief paragraph that I read as a graduate student and still rings true to me today. And the authors of this article wrote, "We suggest that representative designs, meaning high ecological validity designs, are inadequate for testing causal hypotheses, that ecological validity may facilitate the formulation of population estimates, but is not necessary for causal hypothesis testing, and that experiments are not conducted to establish population estimates. Moreover, the meaning that subjects assign to the laboratory setting and their actions, rather than the laboratory's mundane realism, affects the generalizability of laboratory results. We emphasize, as other writers have, that whether laboratory results are generalizable to other situations is an empirical question." So that article was authored by Len Berkowitz and Ed Donnerstein. It was published in 1982, and their article was about really a spirited defense of laboratory research on aggression. So it was published 30 years ago, and it really seems relevant to our discussion today, and I wanted to focus on that for a bit and try to put what we're doing in their context. So they're saying that representative designs are inadequate for testing causal hypotheses, but that ecological validity facilitates the formulation of population estimates. So what could that mean? If I'm interested in, for example, understanding what typical medical malpractice awards are and how they may have changed over time, I'm probably not going to get a lot of value of conducting laboratory research and looking at the value of those awards, but I might do as Neil has done and look at archival research on actual cases, and that may help me address that question. But if I'm interested in establishing a causal relationship, understanding psychological processes, for example, looking at what is the effect of a doctor's apology on the size of medical malpractice awards, then laboratory might be a good way to start, where I can hold the evidence constant and vary just that one variable. But I also wanted to draw attention to one specific aspect of this pertaining to generalizability, where Berkowitz and Donnerstein said, the meaning that subjects assign to the laboratory setting and their actions rather than the laboratory's mundane realism affects the generalizability of laboratory results. I really think that's worth thinking about and being critical of our own laboratory research. I'm not sure that we always give enough attention to the meaning that subjects are assigning to our laboratory settings. And Brian asked the question about what are some of the things that may explain less laboratory research being published in LHB. Well, I was editor for LHB for 6.5 years and saw dozens, hundreds of reviews on jury research. And I think, one of the reasons why a lot of the research doesn't get published in LHB is not a matter of ecological validity, it's a matter of internal validity. And that there's often not enough attention to the meaning that subjects assign to their actions in the lab. And ecological validity may play a role here. So Dan, for example, gave us some excellent suggestions of how to increase ecological validity. Those suggestions may actually not only affect ecological validity, but they could affect internal validity in the sense that they affect how people perceive their role in the lab. So Margaret took us on a tour of the jury, the courtroom upstairs, nice laboratory. Being in that kind of setting may affect the way subjects interpret their tasks. To the extent that subjects are motivated to make legal judgments and pay attention to the tasks at hand and make legal judgments, maybe it's less important that those legal judgments have no consequences. But the laboratory setting, it may help in that respect. It may help internal validity, but it may not be essential, to the extent that participants over the internet in an internet-based study are also interpreting their behavior in line with it in how we'd expect for them to be making judgments. That would bode well for generalizability as well. I still find Berkowitz and Donnerstein's framework useful for understanding the interplay of ecological, internal, and external validity. I guess unlike Dan and Edie, I don't see these validities as a balancing act. I don't see our role as to balance our attention to the various types of validity. When I think of balancing, I think of a compromise, and I don't think that benefits the science. In my view, we need to very carefully select the problems that we're going to study, and from that very carefully select the methods that we're going to use. And as Norb said, each method is going to have benefits and it's going to have drawbacks, and we need to accept what those are. Another area in which I've seen critical reviewer comments on jury research, it's not so much whether a methodological feature existed, whether it was high or low ecological validity, but it was really a match between the problem studied and the method that was used. So if the goal is to make a statement about how courts operate, but then use non-representative designs, there's a bit of a mismatch there. So one source advice that I would give is to be more sensitive to, not to select features that will appeal to reviewers, but select methods and features that are important for the question that are under investigation. Likewise, one of the things that I haven't seen very much in manuscripts, both unpublished and published, is justification that the methods, of the methods that are selected. I see a lot of justifications given in response to reviewers' comments, if we're lucky to get that far, but it's a much better practice in the introduction and the method to justify why the methods that are selected are appropriate for the problem under investigation. Help the reviewers contextualize the roles of ecological and internal validity, and I think you'll have an easier go of it. I'm down to just a couple minutes and want to allow time for discussion, but I will just briefly comment on each of the papers. Brian has a wonderful broad perspective on jury research. I found very little to disagree with in your presentation. It's very, very well done. Sorry, I have. I'm recovering. Thank you. It's a process. And Dan, again, I think the suggestions that you gave are useful in more ways than you mentioned, more than just ecological validity, and I think you're pushing the boundaries in interesting ways. Mary, I think I wrote to you about this. I think your study is very interesting, very important. It also highlighted for me an area in which multiple methodological approaches could be. I drew a parallel between your approach to studying the court's perceptions of ecological and external validity with the research that came out of Margaret and her colleagues' labs on how judges view internal validity, essentially. Their, Brad, Laura, their sensitivity to design flaws in research. Related questions, different methodological approaches, and this is an area where triangulation, I think, could be useful. A quick comment on one of Ted's points. Ted, you raised an issue about what happens when the research from high ecological validity, well, from actual trials doesn't validate what happens in the lab. Does that, that calls into question the validity of the laboratory findings? Not necessarily. It could, but not necessarily. And I'll again, like others, draw an example from eyewitness research, but this could come from other fields as well. There's a fair amount of laboratory research on the role of high stress on eyewitness identification, and generally the laboratory research shows that high stress impairs memory. There's some field research of actual crimes in which there's a tendency for high stress to improve eyewitness memory, and this has been used as an example of why the laboratory research. Sorry? Okay. But it has been cited in the literature and in cases that the laboratory research doesn't generalize to actual crimes. But if you look critically at the field research, you have typical problems with field research. Variables are confounded. In the field research, the high stress situations co-occur with other variables such as close proximity to the crime. So it's just not clear what the role of stress is in that case. And I'm not suggesting that we believe laboratory research over field research in juries, but we have to look at all of these methodologies critically in drawing our conclusions. Thank you very much.
I must say this has stimulated a lot of thoughts in me, as I've sort of mentioned to you at the break, on a lot of these things. Especially thinking about Norb and I had a brief discussion at lunch. Like, I was trained in the lab as he was. In fact, we had the same advisor. One of them, Joe McGrath, was my principal advisor. But over the years, I became more and more interested in applied work. And therefore, although I still do and have laboratory research, I think you can learn a lot from the field. And I kind of want to make a pitch on that in certain respects. In fact, I know Ted knows this, but just in case it escaped other people's things, the findings of juries in using archival data, juries are not very favorable to defendants, or I mean to plaintiffs in these cases. It's 1 in 4. But there's a good reason for that. In med-mal cases, and I learned this, and this goes back to sitting in the jury room and observing what's going on, in med-mal cases, medicine is practiced in a teamwork. When something goes wrong, 4 doctors, for example, are sued. 3 of them say, yeah, we screwed up. And so the trial goes forward only against the 4th person, okay, who says, I didn't screw up. And so when you look at the statistics, it turns out most of the time the defendant prevails. But that doesn't mean that there wasn't med-mal. And so you have to look at the quality of the case that went forward and what the jury was deciding. The second thing I had a thought on was counting, as Mary Rose just did, the citations doesn't really tell the full story about the impact that we sometimes have. And I'm still smarting from the fact that when I was still back in Canada, I wrote a wonderful little amicus brief to the Canadian Supreme Court, and those bastards stole my amicus brief and didn't cite me. It's word for word. And I'm still accusing them of plagiarism. But I have 2 recent examples, or 3 recent examples, that I think some of you may have signed on to the amicus briefs at some point in time. I did a amicus brief over the pain and suffering component in med-mal cases, the cap on pain and suffering in Illinois. I understand from the lawyers that the kind of arguments that went forward in the oral arguments were very much, but when the decision came down, they didn't cite the social science. They just cited legal reasoning. That doesn't mean that they weren't heavily influenced by it. The same thing happened, and I know that it had an impact. I think some of you may have signed on to the amicus brief I wrote on the same topic in Missouri, and Supreme Court of Missouri just overturned the cap on pain and suffering in med-mal cases. I heard the oral arguments because they were done right. It had an impact, but Vidmar is nowhere cited, nor are the rest of you in those instances. And recently in Connecticut, it's the same thing. Again, I'm talking about some personal experiences on these instances where we didn't get the credit to which we were due. And I just have one final thing, and it takes me back to the med-mal stuff and maybe some hints for you. When I was studying med-mal back in the 1990s, early when I first got to Duke, I was sitting in the courtroom, and why I think it's so important in some ways to do those kinds of studies. I'd sit there in the morning. I had classes in the afternoon, but I'd sit through the trial in the morning, and I had a law student come in the afternoon, okay? I'd try to talk to the lawyers at the break. I got nowhere with those guys. I was a professor. Students came in the afternoon, and they spilled their guts out teaching the student. I'm actually using that methodology, or hoping to use that methodology right now, where I've done a switch with my colleagues, and we're trying to look at discretion at the prosecutorial level. We're going to use law students as our data collectors rather than the Vidmar and the Coleman and the Newman, because I think that same thing will apply. So that's just a hint. If you want to do qualitative data, systematic qualitative data, there are different ways to collect it. And to me, is just one of the hints that something I've learned over the years. So I've got a few more ideas, but I should shut up.
Can I comment on? Sorry. Can I comment on the previous panel? And I know I'm probably 3 hours late, but then again, I'm still in California time, so that should be okay. No, but it's stuff, Margaret, you raised and left me with wondering. It was the question of Gary's student, you know, what's publishable, right? And the difficulty of answering the question. And I think we got an answer today. And I think one of Norb's slides, I think, nailed this question. It was what's worth doing. I think you said something that's sort of counterintuitive or not trivial. If I remember correctly, you said it affects the real life. It can be sort of changed by policy, i.e. system variables again. And there might have been another factor. That's, I think, a great little credo to hang on the wall in every single grad student's office, along with construct validity, because that seems to be where people fail the most. So that would be my suggestion to help out people figure out which way to go.
My quip to Brad was that I think we may be succeeding at the trial level far more often than we have in the past in terms of bringing our research to bear in the courtroom. And of course, we'll never see a track record on that other than our personal experiences being in the courtroom. And that is my personal experience, that the research gets more attention. I also just want to say that I find it somewhat irritating to hear all this talk about ecological validity. I think there's a good chance that I've never written the word ecological validity. I think it's equally likely I've never written the word verisimilitude. A large part of the reason for that is that I think that all ecological validity is, at least in our area, is marketability. It's just about marketing our research findings. And when I'm writing about my science, I'm not writing about marketing issues. I'm conscious of the marketing issues in thinking about research, but the idea of putting the word validity together with the word ecological, I just find offensive. I think we give too much attention to this notion. It's just marketability. That's the way it's played out. And I think it's important that our students recognize that, and also that we understand that. Now, there may be other areas of psychology where it comes into play and has more meaning, but I don't see it in our research.
I just wanted to comment on one thing that Dan said that really struck with me, is that sometimes as you increase ecological validity, you're actually compromising external validity. And maybe it's because we've talked about eyewitnesses so much today, or eyewitness research, but I think we could really take a cue from them as far as perhaps engaging in some more stimulus sampling with our research. So instead of using the same trial and then just manipulating certain aspects of it, use different trials, different witnesses, different instructions, so that you engage in a little bit more stimulus sampling at the end of the day, so you can help with that external validity problem.
Mary, I really liked your paper on the ways in which law and human behavior was cited in the courts. I do think that the question of impact should be broadened. I don't know if you have to do that in your particular paper. Maybe a consideration at the trial level or other sorts of things that have been suggested. But I also think that the work of people in this room has been tremendously important in the jury reform area. And that's not necessarily something that will make it into court opinions, but it does make it into state jury reform reports that quite typically cite extensively from empirical jury research of all kinds, experiments, archival studies, interview studies. You know, I'm thinking of the work on jury instructions, the work on different kinds of trial procedures, those sorts of things that courts do have to make, and court systems have to make decisions about, I think have been very favorably, positively affected by the body of research that many of us in this room have developed. You know, we're not completely there yet, but it's nice to see that that work is being sought out and sometimes relied upon. And here, can I make a pitch for your conference, Sherry, for next week? Sherry and one of the judges who is associated with the American Bar Association project on the jury are co-organizing.
Chief Judge Halderman, the chief of the Northern District of Illinois.
Okay, great, thank you. Have co-organized the optimal jury trial, which is going to be held next week in Chicago, and maybe you would just say a little bit about it and talk about it, because I think it is another illustration of the way in which jury research is having an impact by people who are trying to think about how to maximize the jury trial.
So the conference next week is very different from this conference. I mean, it's almost diametrically opposed in form and purpose. A lot of us around the room have done work on optimizing the jury trial with various different procedures. These are, of course, system variables that we're talking about permitting jurors to submit questions during trial and so forth. And what we've learned since the 2005 Principles on Juries and Jury Trials is that, and from the State of the States survey, is that getting them adopted turns out to be a huge hurdle. And one of the things we thought was, would it be possible to I guess proselytize is the best way to describe it. And so the conference at Northwestern next Thursday and Friday, which will have streaming video, and you can get on the Northwestern website if you can't come in person, is set up so that we made videotapes over the summer with actual attorneys and judges implementing some of these procedures to show people how it was actually done. So we have a simulated jury, and we have a juror excused for cause based on things that go beyond traditional Batson. We have jurors submitting questions in the course of the trial, and the decision about whether to allow them to be asked and so forth. And we have and this actually in some ways relates to what Neil said. We have 3 jurors who are going to be participating. The foreperson of Governor Blagojevich's second trial, a juror from a patent trial, and and a third juror who is a surprise. I can't explain. I can't say. And we have a couple of juror consultants. We have scholars. Valerie is going to be moderating one of the panels, and Mary's going to be there as well, and on a panel, and plaintiffs' attorneys and defense attorneys, and on the criminal and civil side, both. The idea being that you have 2 parallel trials, a criminal and a civil trial, and you see how these things play out. So I've talked longer than I should, but if you're at all interested, just please let me know or go to the website. But I think the point for us here is that if we care about policy, judges are frequently, masters of their terrain, and even if there is no opinion in the district or in the circuit that prevents them from doing something, it doesn't say that they're actually going to do it. And something as mundane as permitting jurors to take notes. There was a long time in Illinois where it was on the books, but it wasn't happening because they didn't have to give them paper and pencil or tell them that they could take notes. I mean, the implementation of any of these things is a much longer haul than most of us would like to believe. And so we're trying to do something about it.
I have 2 comments. The first is that a few minutes ago, Christina leaned over and said that she has used the word verisimilitude in an article, and Penrod was a co-author. So you've been outed, Steve. My more substantive comment is I was intrigued by Edie's question about how much disagreement between decision makers we should be willing to accept. And I don't know much about civil commitment cases and the evidence that comes up in those, but in looking at judge-jury agreement and disagreement, these are trials which are only going to trial because they're very close cases. So when I look at these studies, I think if it's over 50%, that's really good. You know, and the low end was 60 and up to, you know, the upper 80%, 90%. I think that's an impressive rate of agreement for cases which in the vast majority of cases a reasonable verdict could come down either way.